she request confidentiality at this point?
When she said she...
Let me, if I can answer that question. Professor Hill says that she wants to tell her story. She did not release the statement, she says, and she wants her story told by her. Because we have given the opportunity the judge to speak first, if he so chose, and he has, that she wants to be able to use her statement in her own words that she has thus far not released and has not spoken to publicly. She has not spoken to publicly when she comes and addresses the committee. Now, why don't we get on with this process?
Well, Mr.
You
Chairman,
can.
I'm not finished.
Mr. Chairman, wait just a minute.
Okay.
Mr. Chairman, she has been on television telling her story. She's made it public. So therefore, I think the right to use that statement ought to be admitted.
Mr. Chairman, I didn't want to use the floor. I did to the chairman because the chairman, I want to finish my comment.
Let the senator from Massachusetts, then we'll go back. Everybody's going to get a chance to say whatever.
We'll come back
It
to me.
seems to me that you outlined a reasonable way of proceeding. I think it's entirely proper that Judge Thomas be able to make what statement that he so desired. And I thought it was a very moving statement, Judge. It might be appropriate, if that is the desire, that at least we work out in terms of the committee and the committee's understanding the way that we're going to proceed on this. As I understand, the professor had indicated willing to testify first or go second, and now we're in the situation where Judge Thomas has spoken. And it seems to me that we ought to be able to work out at least the way that we're going to proceed that is going to be respectful both of Judge Thomas and the witness without getting into a lot of back and forth up here, which is not really the purpose of the hearing. And what I might suggest, at least, is that we have a very brief recess so that we can at least find out a way that we can proceed that is consistent with Judge Thomas, consistent with the others, and satisfactory to the way that the committee.
Mr. Chairman,
The senator from Utah.
I object to a recess. The fact of the matter is, last Tuesday, a substantial majority of the Senate frankly asked us to get to the bottom of this. The public deserves to know now, one way or the other. And the public's going to know if I have anything to say about it. Our colleagues demanded it. They didn't ask us to just find out so much as the witness will allow us to ask. And I have no intention of pillaring or maligning Professor Hill. I feel sorry for both of these people. Both of them are going to come out of this with less of a reputation. It's pathetic, and it wouldn't have happened. Let me finish if I could. If somebody on this committee or their staff had the honesty and the integrity before the vote to raise this issue and ask for an executive session and say this has to be brought out. Nobody did. And then somebody on this committee or their staff, and I'm outraged by it, leaked that report, an FBI report that we all know should never be disclosed to the public because of the materials that generally are in them. They take it down as it's given. It's got raw stuff in it, that it's been leaked. Half the media knows everything in it. And I think the American people are entitled to know if they want to. And what I'm trying to say is that, to be frank, Mr. Chairman, there are inconsistencies in the statement of Anita Hill to the FBI compared to her other statements. I don't particularly intend to go into that. She's entitled to explain these discrepancies. But Judge Thomas is entitled to point out these inconsistencies for their bearing on the credibility of the accuser in this instance. Nice person though she may be, good law professor though she may be, fellow Yale law graduate though she may be.
Senator,
And the
Mr.
statement, if I
Chairman.
could just finish, the statement,
Please.
I promise to be shorter. The statements of the subsequent witnesses are also at variance with Professor Hill's statements, with what she told the FBI. If she happens to testify differently today, we have to find out which of those
Senator-
statements are true. Now, if
Senator, we
I,
are not at liberty to publicly discuss what's in the FBI report. Her statement
the
is a
heck,
different
we're
story.
not. This report's been leaked to the press. They know about it. Part of it's been read to the accuser in this case. I think it's time to be fair to the nominee. If he's come this far, he's the one who's being accused. They have the burden of showing that he's not telling the truth here, and he has a right to face the accuser and everything that accuser says. And if he doesn't, then I'm going to resign from this committee today. I'm telling you, I don't want to be on it.
The Senate's in recess. The hearing is in recess for 5 minutes. The hearing will come to order. The committee has met and resolved the impasse in the following way. Professor Hill indicated on the telephone that she was prepared to have her statement released. And in further discussion with the committee and others involved, it has been determined that we will excuse temporarily Judge Thomas, and we will call momentarily as the witness Anita Hill. Anita Hill will be sworn and make her own statement in her own words, at which time we would then begin the questioning of Professor Hill, after which we will bring back Judge Thomas for questioning. Now the committee will stand in recess until, and I imagine it's only momentarily, as the professor will be here momentarily, but we'll stand in recess until she is able to take her seat, which should be a matter of a minute or so. I'm told security is clearing the hall. She's in the hall so that she can come down.
You've been watching the 1991 confirmation hearing for then Supreme Court nominee Clarence Thomas, who was facing allegations of sexual harassment at the time from Anita Hill. We've been showing it to you as the Senate Judiciary Committee prepares for a hearing tomorrow with Christine Blasey Ford, who was accused Supreme Court nominee Brett Kavanaugh of sexual assault in high school. Brett Kavanaugh will also be testifying at that hearing. That's live tomorrow at 10 a.m. Eastern on C-SPAN 3. Next, we go back to the hearing in 1991 with Anita Hill sharing her testimony. This portion includes her opening statement and questions from Senators Joe Biden and Arlen Specter.
Welcome, Professor Hill.
Thank you.
Professor, let me explain what the procedure will be while your family and others are being seated. In a moment, I will ask you to stand to be sworn, at which time, when that is finished, we will invite you to make any statement that you wish to make. And then what we will do is I will begin by asking you some questions, and then Senator Specter will ask you some questions, and then Senator Leahy will ask you some questions, and then I assume it will be Senator Specter again, but I am not certain of that. We'll ask you questions. And again, welcome. We're happy that you are here, and let us stand and be sworn, if you will. Professor, do you swear to tell the whole truth and nothing but the truth, so help you God?
I do.
Thank you. Professor Hill, please make whatever statement you would wish to make to the committee.
Mr. Chair,
Excuse me, friend. I instruct the officers, do not let anyone in or out of that door while Professor Hill is making her statement.
Mr. Chairman, Senator Thurmond, members of the committee, my name is Anita F. Hill, and I am a professor of law at the University of Oklahoma. I was born on a farm in Okmulgee County, Oklahoma in 1956. I am the youngest of 13 children. I had my early education in Okmulgee County. My father, Albert Hill, is a farmer in that area. My mother's name is Irma Hill. She is also a farmer and a housewife. My childhood was one of a lot of hard work and not much money, but it was one of solid family affection as represented by my parents. I was reared in a religious atmosphere in the Baptist faith, and I have been a member of the Antioch Baptist Church in Tulsa, Oklahoma since 1983. It is a very warm part of my life at the present time. For my undergraduate work, I went to Oklahoma State University and graduated from there in 1977. I am attaching to this statement a copy of my resume for further details of my education. Thank you. I graduated from the university with academic honors and proceeded to the Yale Law School, where I received my JD degree in 1980. Upon graduation from law school, I became a practicing lawyer with the Washington, D.C. firm of Wald, Harkrader, and Ross. In 1981, I was introduced to now Judge Thomas by a mutual friend. Judge Thomas told me that he was anticipating a political appointment, and he asked if I would be interested in working with him. He was, in fact, appointed as Assistant Secretary of Education for Civil Rights. After he had taken that post, he asked if I would become his assistant, and I accepted that position. In my early period there, I had two major projects. The first was an article I wrote for Judge Thomas's signature on the education of minority students. The second was the organization of a seminar on high-risk students, which was abandoned because Judge Thomas transferred to the EEOC, where he became the chairman of that office. During this period at the Department of Education, my working relationship with Judge Thomas was positive. I had a good deal of responsibility and independence. I thought he respected my work and that he trusted my judgment. After approximately 3 months of working there, he asked me to go out socially with him. What happened next and telling the world about it are the two most difficult experiences of my life. It is only after a great deal of agonizing consideration and great number of sleepless nights that I am able to talk of these unpleasant matters to anyone but my close friends. I declined the invitation to go out socially with him and explained to him that I thought it would jeopardize at the time I considered to be a very good working relationship. I had a normal social life with other men outside of the office. I believed then, as now, that having a social relationship with a person who was supervising my work would be ill-advised. I was very uncomfortable with the idea and told him so. I thought that by saying no and explaining my reasons, my employer would abandon his social suggestions. However, to my regret, in the following few weeks, he continued to ask me out on several occasions. He pressed me to justify my reasons for saying no to him. These incidents took place in his office or mine. They were in the form of private conversations which would not have been overheard by anyone else. My working relationship became even more strained when Judge Thomas began to use work situations to discuss sex. On these occasions, he would call me into his office for reports on education issues and projects, or he might suggest that because of the time pressures of his schedule, we go to lunch to a government cafeteria. After a brief discussion of work, he would turn the conversation to a discussion of sexual matters. His conversations were very vivid. He spoke about acts that he had seen in pornographic films involving such matters as women having sex with animals and films showing group sex or rape scenes. He talked about pornographic materials depicting individuals with large penises or large breasts involved in various sex acts. On several occasions, Thomas told me graphically of his own sexual prowess. Because I was extremely uncomfortable talking about sex with him at all, and particularly in such a graphic way, I told him that I did not want to talk about these subjects. I would also try to change the subject to education matters or to non-sexual personal matters, such as his background or his beliefs. My efforts to change the subject were rarely successful. Throughout the period of these conversations, he also from time to time asked me for social engagement. My reaction to these conversations was to avoid them by eliminating opportunities for us to engage in extended conversations. This was difficult because at the time I was his only assistant at the Office of Education, or Office for Civil Rights. During the latter part of my time at the Department of Education, the social pressures and any conversation of his offensive behavior ended. I began both to believe and hope that our working relationship could be a proper, cordial, and professional one. When Judge Thomas was made chair of the EEOC, I needed to face the question of whether to go with him. I was asked to do so, and I did. The work itself was interesting, and at that time it appeared that the sexual overtures which had so troubled me had ended. I also faced the realistic fact that I had no alternative job. While I might have gone back to private practice, perhaps in my old firm or at another, I was dedicated to civil rights work, and my first choice was to be in that field. Moreover, at that time, the Department of Education itself was a dubious venture. President Reagan was seeking to abolish the entire department. For my first months at the EEOC, where I continued to be an assistant to Judge Thomas, there were no sexual conversations or overtures. However, during the fall and winter of 1982, these began again. The comments were random and ranged from pressing me about why I didn't go out with him to remarks about my personal appearance. I remember his saying that someday I would have to tell him the real reason that I wouldn't go out with him. He began to show displeasure in his tone and voice and his demeanor, and his continued pressure for an explanation. He commented on what I was wearing in terms of whether it made me more or less sexually attractive. The incidents occurred in his inner office at the EEOC. One of the oddest episodes I remember was an occasion in which Thomas was drinking a Coke in his office. He got up from the table at which we were working, went over to his desk to get the Coke, looked at the can and asked, "Who has put pubic hair on my Coke?" On other occasions, he referred to the size of his own penis as being larger than normal, and he also spoke on some occasions of the pleasures he had given to women with oral sex. At this point, late 1982, I began to feel severe stress on the job. I began to be concerned that Clarence Thomas might take out his anger with me by degrading me or not giving me important assignments. I also thought that he might find an excuse for dismissing me. In January of 1983, I began looking for another job. I was handicapped because I feared that if he found out, he might make it difficult for me to find other employment, and I might be dismissed from the job I had. Another factor that made my search more difficult was that this was during a period of a hiring freeze in the government. In February 1983, I was hospitalized for 5 days on an emergency basis for acute stomach pain, which I attributed to stress on the job. Once out of the hospital, I became more committed to find other employment and sought further to minimize my contact with Thomas. This became easier when Allison Duncan became office director, because most of my work was then funneled through her, and I had contact with Clarence Thomas mostly in staff meetings. In the spring of 1983, an opportunity to teach at Oral Roberts University opened up. I participated in a seminar, taught an afternoon session in a seminar at Oral Roberts University. The dean of the university saw me teaching and inquired as to whether I would be interested in pursuing a career in teaching, beginning at Oral Roberts University. I agreed to take the job in large part because of my desire to escape the pressures I felt at the EEOC due to Judge Thomas. When I informed him that I was leaving in July, I recall that his response was that now I would no longer have an excuse for not going out with him. I told him that I still preferred not to do so. At some time after that meeting, he asked if he could take me to dinner at the end of the term. When I declined, he assured me that the dinner was a professional courtesy only and not a social invitation. I reluctantly agreed to accept that invitation, but only if it was at the very end of a working day. On, as I recall, the last day of my employment at the EEOC in the summer of 1983, I did have dinner with Clarence Thomas. We went directly from work to a restaurant near the office. We talked about the work I had done, both at education and at the EEOC. He told me that he was pleased with all of it, except for an article and speech that I had done for him while we were at the Office for Civil Rights. Finally, he made a comment that I will vividly remember. He said that if I ever told anyone of his behavior, that it would ruin his career. This was not an apology, nor was it an explanation. That was his last remark about the possibility of our going out or reference to his behavior. In July of 1983, I left Washington, D.C. area and have had minimal contacts with Judge Clarence Thomas since. I am of course aware from the press that some questions have been raised about conversations I had with Judge Clarence Thomas after I left the EEOC. From 1983 until today, I have seen Judge Thomas only twice. On one occasion, I needed to get a reference from him, and on another, he made a public appearance in Tulsa. On one occasion, he called me at home and we had an inconsequential conversation. On one occasion, he called me without reaching me, and I returned the call without reaching him, and nothing came of it. I have, on at least 3 occasions, been asked to act as a conduit to him for others. I knew his secretary, Diane Holt. We had worked together at both EEOC and Education. There were occasions in which I spoke to her, and on some of these occasions, undoubtedly, I passed on some casual comment to then Chairman Thomas. There were a series of calls in the first 3 months of 1985, occasioned by a group in Tulsa, which wished to have a civil rights conference. They wanted Judge Thomas to be the speaker and enlisted my assistance for this purpose. I did call in January and February to no effect, and finally suggested to the person directly involved, Susan Cahall, that she put the matter into her own hands and call directly. She did so in March of 1985. In connection with that March invitation, Ms. Cahall wanted conference materials for the seminar, and some research was needed. I was asked to try to get the information and did attempt to do so. There was another call about another possible conference in July of 1985. In August of 1987, I was in Washington, D.C., and I did call Diane Holt. In the course of this conversation, she asked me how long I was going to be in town, and I told her. It is recorded in the message as August 15th. It was, in fact, August 20th. She told me about Judge Thomas's marriage, and I did say, congratulate him. It is only after a great deal of agonizing consideration that I am able to talk of these unpleasant matters to anyone except my closest friends. As I've said before, these last few days have been very trying and very hard for me. And it hasn't just been the last few days this week. It has actually been over a month now that I have been under the strain of this issue. Telling the world is the most difficult experience of my life, but it is very close to having to live through the experience that occasioned this meeting. I may have used poor judgment early on in my relationship with this issue. I was aware, however, that telling at any point in my career could adversely affect my future career. And I did not want early on to burn all the bridges to the EEOC. As I said, I may have used poor judgment. Perhaps I should have taken angry or even militant steps, both when I was in the agency or after I left it. But I must confess to the world that the course that I took seemed the better as well as the easier approach. I declined any comment to newspapers, but later when Senate staff asked me about these matters, I felt I had a duty to report. I have no personal vendetta against Clarence Thomas. I seek only to provide the committee with information which it may regard as relevant. It would have been more comfortable to remain silent. It took no initiative to inform anyone. I took no initiative to inform anyone. But when I was asked by a representative of this committee to report my experience, I felt that I had to tell the truth. I could not keep silent.
Thank you very much. Judge, Professor, before I begin my question, notice there are a number of people sitting behind you. Are any of them your family members you'd like to introduce?
Well, actually, my family members haven't arrived yet. Perhaps yes, they have. They're outside the door. They weren't here for my statement.
Well, we will make room for your family to be able to sit.
It's a very large family,
Well,
Senator.
we will begin, but attempt to accommodate as quietly as we can what may be an unusual arrangement. I might ask, is everyone who is sitting behind you necessary and to sit behind you, and maybe they could stand and let your family sit? But we will, I would assume the reason why, to make it clear, the reason why your family is not here at the moment is that you did not anticipate coming. So if those who aren't absolutely necessary would stand with the rest of our staffs and let family members come in. Now, and we'll try to get a few more chairs if possible, but we should get this underway. My Lord. Is staff trying to get some chairs? Did you get some chairs? Staff just began to carry some chairs out over there so we can. Let's bring out chairs, whatever you have. I would ask.
Well, you all can stand.
We may at some point, Professor Hill, attempt to have to accommodate either your counsel and or your family members with chairs down the side there. They need not all be up front here. We cannot completely reconfigure this situation, okay? Fine, we can put them in the back as well. Now, would you, there are two chairs on the end here, folks. We must get this hearing moving. With there two chairs on the end here. We will find everyone a seat, but we must begin. Now, Professor Hill, at the risk of everyone behind you standing up, would you be kind enough to introduce your primary family members to us?
Okay. I'd like to introduce, first of all, my father, Albert Hill.
Mr. Hill, welcome.
My mother, Irma Hill.
Miss Hill.
My mother is going to be celebrating her 80th birthday on the 16th.
Happy birthday in advance.
My sister, my eldest sister, Elretha Lee, is here. My sister, Joanne Fennell. My sister, Carlene Gilcrease. My sister, Joyce Baird.
I welcome you all. I'm sorry?
My brother, Ray Hill. I think that's everyone.
Thank you, Professor.
I'm sorry.
Please.
I would also like to introduce my counsel at this time.
Yes, that'd be appropriate.
Mr. Gardner, Miss Susan Ross, and Mr. Charles Ogletree.
Thank you. Now, Professor, thank you for your statement and your introductions, and I think it's important that the committee understand a little more about your background and your work experience before we get into the specific allegations that you have made in your statement. I understand, as you've just demonstrated, you come from a large family, and I've been told that that you indicated you're the youngest in the family. Is that correct?
Yes, I am.
Now, I assume that, like all families, they've been of great help and assistance to you. Let me ask you, tell me again your educational background for the record.
I went to primary, elementary, and secondary school in Okmulgee County, in Morris High School, Morris Junior High, and Urim Grade School. It's in reverse order. I went to Oklahoma State University starting in 1973 and graduated in 1977 from Oklahoma State University with a degree in psychology. In 1977, I began attending Yale Law School. I graduated, received my JD degree from there in 1980.
Now, what was your first job after graduation from law school?
I worked at the firm of Wald, Harkrader and Ross.
How did you acquire the job? And that is a Washington law firm.
That is a Washington, D.C. law firm.
And how did you acquire that job?
Through the interviewing process, the first interview took place at Yale Law School. I was interviewed for that job. I don't remember the names of the interviewers. I was called to Washington for an interview in the office of Wald, Harkrader and Ross. I was interviewed by a number of people, and I accepted an appointment with them. Now, I will say that that interview process was preceded by work that I had done with them as a summer associate. And so the interview process the second time around was really, well, actually, I'll say that the interview process took place before the summer associateship. And then at the end of that summer associateship, I was asked to work there full time.
Who was your immediate supervisor when you were at that law firm?
Well, a number of individuals. I worked with a number of different attorneys on different projects.
So it would depend upon the project you were working on.
Yes.
Now, what type of work did you do while you were at the law firm? Was it specialized, or did you do whatever was asked of you of any of the partners?
Well, since I worked there for only 1 year. I was a fairly new associate. Most of my work was basically what was available and when I had time available to do it. However, I did some federal trade work. I did some environmental law work there, and I participated in the drafting of a manual on banking law while I was there.
Now, did you decide you wanted to leave that law firm, or was it suggested to you?
It was never.
Did someone approach you and say there's another job you might like, or did you indicate that you would like to leave the law firm to seek another job?
I was interested in seeking other employment. It was never suggested to me at the firm that I should leave the law firm in any way.
How old were you at this time?
At the time, I was 24 years old.
Now, why were you dissatisfied at the law firm? Why did you want to leave?
Well, I left the law firm because I wanted to pursue other practice other than basically the commercial practice, civil practice that was being done at the law firm. I was not dissatisfied with the quality of the work or the challenges of the work. I thought that I would be more personally fulfilled if I pursued other fields of the law.
Now, again, were you approached as to the opportunity at the Department of Education, or were you aware that there was a potential opening and you sought it out?
I spoke only with Clarence Thomas about the possibility of working at the...
Excuse me. How did you get to Clarence Thomas? That is my question.
I was introduced to him by a mutual friend.
Was the mutual friend a member of the law firm for which you worked?
Yes, his name is Gilbert Hardy. He was a member of the firm which I worked, Walt Hart Grader and Ross.
So you had expressed to Mr. Hardy that you would like to move into government or move out of the practice. Were you specific in what you would wanted to do?
I told him only that I was interested in pursuing something other than private practice.
Now, some of the activities of the Office of Civil Rights at the time were pretty controversial. We heard testimony, in fact, about the fact the office was under a court order to change its practice for carrying out its duties, and some have suggested that Mr. Thomas had done an exemplary job in changing things. Some have suggested otherwise. Did the controversy surrounding the office detract from your interest in taking this job, or did you consider it?
Oh, I certainly considered it. I considered the fact that there was talk about abolishing the office. I considered all of those things, but I saw this as an opportunity to do some work that I may not get at another time.
Did you think this was a good job?
Pardon me?
Did you view this as a good job, or did you view this as an intermediate step?
I viewed it as a good job, yes.
Can you describe for the committee your duties, initial duties, when you arrived at the office of, at the Department of Education and doing in the civil rights area? What were your duties?
My duties were really special projects and special research. A lot of the special projects involved commenting on Office for Civil Rights policies. It involved doing research on education issues as they related to socioeconomic factors and so forth.
Was Judge Thomas your direct supervisor? Did you report to anyone else but Judge Thomas
I
at the time?
reported only to Judge Thomas.
So at the Department of Education, your sole and immediate supervisor was Judge Thomas.
Yes.
And what was your title?
Attorney advisor.
Attorney advisor. Now, did you have reason to interact with Judge Thomas in that capacity very often during a day?
We interacted regularly.
Did you attend meetings with Judge Thomas?
I would attend some meetings, but not all of the meetings that he attended.
Perhaps you'd be willing to describe to the committee what a routine workday was at that phase of your career in working with Judge Thomas.
Well, I'm not sure that there were any such thing as a routine workday. Some days I would go in, I might be asked to respond to letters that Judge Thomas had received. I might be asked to look at memos that had come from the various offices in the Office for Civil Rights. If there was a meeting which Judge Thomas needed to attend, that he wanted someone there to take information or to help him with information, I might be asked to do that.
Where was your office physically located relative to Judge Thomas's office?
His office was set off down the hall from mine. Inside his set of offices, there was a desk for his secretary, and then his office was behind a closed door. My office was down the hall. It was separated from his office.
Can you describe to us how it was that you came to move over to the EEOC with Judge Thomas?
Well, my understanding, I did not have much notice that Judge Thomas was moving over to the EEOC. My understanding from him at that time was that I could go with him to the EEOC, that I did not have, since I was his special assistant, that I did not have a position at the Office for Education, but that I was welcome to go to the EEOC with him. It was a very tough decision because this behavior had occurred. However, at the time that I went to the EEOC, there was a period, or prior to the time we went to the EEOC, there was a period where the incidents had ceased. And so after some consideration of the job opportunities in the area, as well as the fact that I was not assured that my job at the education was going to be protected, I made a decision to move to the EEOC.
Were you not assured of that because you were a political appointee, or were you not assured of it because, tell me why you felt you weren't assured of that?
Well, there were two reasons, really. One, I was a special assistant of a political appointee, and therefore I assumed and I was told that that position may not continue to exist. I didn't know who was going to be taking over the position. I had not been interviewed to become the special assistant of the new individual. I assumed that they would want to hire their own, as Judge Thomas had done. In addition, the Department of Education at that time was scheduled to be abolished. There had been a lot of talk about it, and at that time it was truly considered to be on its way out. And so, for a second reason, I could not be certain that I would have a position there.
Now, when you moved over to EEOC, can you recall for us, to the best of your ability, how that offer came about? Did you inquire of Judge Thomas whether or not you could go to EEOC? Did he suggest it? Do you recall?
I recall that when the appointment at the EEOC became firm, that I was called into his office, and I believe Diane Holt was there too. And Diane Holt was his secretary at Education. We were there, and he made the announcement about the appointment and assured us that we could go to the EEOC with him.
Now, when you went to EEOC, what were your duties there at EEOC?
Well, my duties were really varied because it was a much larger organization. There were so many more functions of the organization. My primary duties were to the office of being the liaison to the Office of Congressional Affairs and the Office of Review and Appeals, so that I reviewed a number of the cases that came up on appeal to make certain our office had given proper consideration. I acted as a liaison to the press, sometimes for the chairman's office through Congressional Affairs and Public Relations. I had some additional responsibilities as special projects came along.
Did you have as much occasion to interact personally with Judge Thomas at EEOC as you had with him at the Department of Education?
No. We were much busier. We were all much busier, and the work that we did was work that did not necessarily require as much interaction. A lot of times at the Education Department, the work required there were policy decisions that were to be made, and we were trying to do an evaluation of the program. So there was more interaction at that time. At EEOC, there were just projects that had to get out, and so there was less of an opportunity for interaction.
Who was your immediate supervisor at EEOC?
At the EEOC, initially, Clarence Thomas was my immediate supervisor. After a period, Allison Duncan was appointed to be the director of the staff. Initially, the staff consisted of 2 special assistants, myself and Carlton Stewart. The staff eventually grew to a larger number of assistants, and Allison Duncan was brought up from the legal counsel's office to take control of that situation.
Now, how long were you at EEOC with Judge Thomas before Allison Duncan became the chief of staff?
I don't recall.
Once she became the chief of staff, is she the person who gave you assignments most often and to whom you reported most often?
That's right. Occasionally at the staff meeting, assignments would be given out, but that was held only one day of the week. So during the rest of the week, when things came up, Allison was in charge of giving out assignments.
Now, did the judge's chief of staff report directly to him, or did she have an intermediate supervisor?
No, she reported directly to him, as I understand.
Who prepared your performance evaluations?
I understood that Judge Thomas prepared the performance evaluations.
Did the chief of staff, to the best of your knowledge, have the power to fire you?
Not to my knowledge.
Who had that power?
Judge Thomas.
Was there anyone else at EEOC that you believe possessed that power?
No, not for that office.
Was Judge Thomas then still your ultimate boss and the boss of the entire office?
Yes.
Now, was there any routine workday at EEOC that you could describe for the committee?
Actually, most of the work that we did, unlike at education, most of the work was responding to internal memos instead of responding to things that had come from outside. There were many more of those because there were many more offices. And so each of us who were responsible for a certain area would respond to a memo or write up a memo to be sent to the chairman for his response. We also had hearings, and there was always a special assistant who was assigned to sit in the commission hearings. And so on some days, if we were having hearings, one of the special assistants, very often it was me, would sit in the hearing to provide the chairman with information. On the weeks or during the days of the week that we weren't having hearings, we had to prepare the chairman for the hearings themselves, so that we had to go through the files on the hearings and the records and brief the chairman on those, or write memos of brief to the chairman on them.
Professor, you've testified that you had regular contact with Judge Thomas at the Department of Education, and you've just described the extent of your contact with Judge Thomas at EEOC. And you've described your professional interaction with him. Now, I must ask you now to describe once again and more fully the behavior that you have alleged he engaged in while your boss, which you say went beyond the professional conventions and were unwelcome to you. Now, I know these are difficult to discuss, but you must understand that we have to ask you about them. Professor, did some of the attempts at conversation that you have described in your opening statement occur in your office or in his office?
Some occurred in his office. Some comments were made in mine. Most often they were in his office.
Did all of the behavior that you have described to us in your written statement to the committee and your oral statement now, and what you have said to the FBI, did all of that behavior take place at work?
Yes, it did.
Now, I'd like you to go back.
Let me clarify that. If you're including a luncheon during the work day to be at work, yes.
Well, I'm just trying to determine, it was in what you could describe and you believe to be part of the work day.
Yes.
Now, I have to ask you, where did each of these events occur? If you can, to the best of your ability, I'd like you to recount for us where each of the allegations that you have mentioned in your opening statement, each of the incidences occurred, physically where they occurred.
Well, I remember 2 occasions these incidents occurred at lunch.
Do you remember which of those
cafeteria.
incidences were at lunch, Judge? Professor? Well, let me ask this as an antecedent question. Were you always alone when the alleged conversations would begin, or the alleged statements by Judge Thomas would begin?
Well, and when the incidents occurred in the cafeterias, we were not alone. There were other people in the cafeterias because of the way the tables were set, or there were few individuals who were in the immediate area of the conversation.
Those incidences that occurred other than in the cafeteria, those incidences occurred in his office. Can you tell me what incidences occurred, of the ones you've described to us, occurred in his office?
Well, I recall specifically that the incident about the Coke can occurred in his office at the EEOC.
And what was that incident again?
The incident with regard to the Coke can that's spelled out in my
Describe it
statement.
once again for me, please.
The incident involved his going to his desk, getting up from a work table, going to his desk, looking at this can and saying, "Who put pubic hair on my Coke?"
Was anyone else in his office at the time?
No,
Was the door closed?
I don't recall.
Are there any other incidences that occurred in his office in his office, period?
There is, I recall at least one instance in his office at the EEOC where he discussed some pornographic material, or he brought up the substance or the content of pornographic material.
Again, it's difficult, but for the record, what substance did he bring up in this instance at EEOC in his office? What was the content of what he said?
Well, this was a reference to an individual who had a very large penis, and he used the name that he had been referred to in the pornographic material.
Do you recall what it was?
Yes, I do. The name that was referred to was Long Dong Silver.
Were you working on any matter when in that context, or you just were called into the office? Do you remember what the circumstance of you being in an office on that occasion?
Very often, I went in to report on memos that I had written. I'm sure that that's why I was in the office. What happened generally was that I would write a note to Clarence Thomas, and he would call me in to talk about what I had written to him. And I believe that's what happened on that occasion.
Let's go back to the first time that you alleged Judge Thomas indicated he had more than a professional interest in you. Do you recall what the first time was, and with as much precision as you can, what he said to you?
As I recall, it either happened at lunch or it happened in his office when he said to me very casually, "You ought to go out with me sometime."
You ought to, or you are to?
You ought to.
Was that the extent at that incident?
That was the extent of that incident. At that incident, I declined. And at that incident, I think he may have said something about, he couldn't understand why I wouldn't want to go out with him, and the conversation may have ended.
Can you describe for the committee how you felt at that time when he asked you out? What was your reaction?
Well, my reaction at that time was a little surprised, because I had not indicated to him in any way that I knew that I was interested in dating him. We had developed a good working relationship. It was cordial and it was very comfortable. So I was surprised that he was interested in something else.
With regard to the other incidences, and my time is running down, and I will come back to them, but with regard to the other incidences that you have mentioned in your opening statement, Can you tell us how you felt at the time? Were you uncomfortable? Were you embarrassed? Did it not concern you? How did you feel about it?
The pressure to go out with him, I felt embarrassed about, because I had given him an explanation that I thought it was not good for me as an employee working directly for him to go out. I thought he didn't take seriously my decision to say no, and that he did not respect my having said no to him. The conversations about sex, I was much more embarrassed and humiliated by. The two combined really made me feel sort of helpless in a job situation, because I really wanted to do the work that I was doing. I enjoyed that work. But I felt that that was being put in jeopardy by the other things that were going on in the office. And so I was really, really very troubled by it and distressed over it.
Can you tell the committee what was the most embarrassing of all the incidences that you have alleged?
I think the one that was the most embarrassing was his discussion of pornography involving these women with large breasts and engaged in a variety of sex with different people or animals. That was the thing that embarrassed me the most and made me feel the most humiliated.
If you can, in his words, not yours, in his words, can you tell us what on that occasion he said to you? You have described the essence of the conversation. In order for us to determine, well, can you tell us in his words what he said?
I really cannot quote him verbatim. I can remember something like, you really ought to see these films that I've seen, or this material that I've seen. This woman has this kind of breast, breasts that measure this size, and they got her in there with all kinds of things. She's doing all kinds of different sex acts, and that kind of those were the kinds of words where he expressed his enjoyment of it and seemed to try to encourage me to enjoy that kind of material as well.
Did he indicate why he thought you should see this material?
No.
Why do you think? What was your reaction? Why did you think he was saying these things to you?
Well, coupled with the pressure about going out with him, I felt that implicit in this discussion about sex was the offer to have sex with him. Not just to go out with him. There was never any explicit thing about going out to dinner or going to a particular concert or movie. It was, we ought to go out. And given his other conversations, I took that to mean we ought to have sex, or we ought to look at these pornographic movies together.
Professor, at your press conference, one of your press conferences, you said that the issues that you raised about Judge Thomas, you referred to as an ugly issue. Is that how you view these conversations?
Yes, they were very ugly. They were very dirty. They were disgusting.
Were any one of these conversations, this was my last question, my time is up, were any one of these conversations, other than being asked to go out, Were any one of them repeated more than once? The same conversation, reference to.
The reference to his own physical attributes was repeated more than once, yes.
Now again, for the record, did he just say, I have great physical capability and attributes, or was he more graphic?
He was much more graphic.
Can you tell us what he said?
Well, I can tell you that he compared his penis size. He measured his penis in terms of length, those kinds of comments.
Thank you. My time is up under our agreement. By the way, I might state for the agreement, once again, we've agreed that we will go back and forth a half-hour conversation on each side, at which time, when the principals finish asking questions, that members who have not been designated to ask questions, since all have been keenly involved and interested in this on both sides, will have an opportunity to ask questions for 5 minutes. But let me now yield to my friend from Pennsylvania, Senator Specter.
Thank you, Mr. Chairman. Professor Hill, I have been asked to question you by Senator Thurman, the ranking Republican, but I do not regard this as an adversary proceeding.
Thank you.
And my duties run to the people of Pennsylvania who have elected me, and in the broader sense as a United States Senator, to constitutional government and the Constitution. And my purpose, as the purpose of the hearing generally, is to find out what happened.
Certainly.
We obviously have a matter of enormous importance from a lot of points of view. The integrity of the court, it is very important that the Supreme Court not have any member who is tainted or not have a cloud. And in our society, we can accept unfavorable decisions from the court if we think they're fairly arrived at.
Senator, excuse me for interrupting, but some of our colleagues on this end can't hear you. Can you pull that closer? I know it makes it
I have done that carefully, Chairman, to avoid that.
Well, you're succeeded, Senator.
You can hear me all right, can't you, Professor Hill?
Yes, I can.
Okay. But I was just saying about the importance of the court, where there should be a feeling of confidence in the fairness of decisions, because parties can take unfavorable decisions if they think they're being treated fairly. I think this hearing is very important to the Senate, to this committee, because by 2020 hindsight, we should have done this before. And obviously, it's of critical importance to Judge Thomas and you, whose reputations and careers are on the line. It's not easy to go back to events which happened almost a decade ago to find out what happened. Very, very difficult to do. I would start, Professor Hill, with one of your more recent statements, at least according to a man by the name of Carlton Stewart, who says that he met you in August of this year, ran into you at the American Bar Association convention in Atlanta, where Professor Hill stated to me in the presence of Stanley Grayson, quote, how great Clarence's nomination was and how much he deserved it, unquote. We went on to discuss Judge Thomas and our tenure at EEOC. For an additional 30 minutes or so, there was no mention of sexual harassment or anything negative about Judge Thomas stated during that conversation, and there's a statement from Stanley Grayson corroborating what Carlton Stewart has said. My question is, did Mr. Stewart accurately state what happened with you at that meeting?
As I recall, at that meeting, I did see Carlton Stewart, and we did discuss the nomination. Carlton Stewart was very excited about the nomination and said, I believe that those are his words, how great it was that Clarence Thomas had been nominated. I only said that it was a great opportunity for Clarence Thomas. I did not say that it was a good thing, that this nomination was a good thing. I might add that I have spoken with newspaper reporters and have gone on record as saying that I have some doubts and some questions about the nomination. However, in that conversation where I was faced with an individual who was elated about the probability of his friend being on the Supreme Court, I did not want to insult him or argue with him at that time about the issue. So I was very passive in the conversation.
Excuse me?
I was very passive in the conversation.
So that Mr. Stewart and Mr. Grayson are simply wrong when they say, and this is a quotation from Mr. Stewart, that you said specifically how great his nomination was and how much he deserved it. They're just wrong.
The latter part is certainly wrong. I did say that it is a great opportunity for Clarence Thomas. I did not say that he deserved it.
We have a statement from former Dean of Oral Roberts Law School, Roger Tuttle, who quotes you as saying that laudatory comments about Judge Thomas as a fine man and an excellent legal scholar, and in the course of 3 years when Dean Tuttle knew you at the law school, that you had always praised him and had never made any derogatory comments. Is Dean Tuttle correct?
During the time that I was at Oral Roberts University, I realized that Charles Cothe, who was the founding dean of that school, had very high regards for Clarence Thomas. I did not risk talking in disparaging ways about Clarence Thomas at that time. I don't recall any specific conversations about Clarence Thomas in which I said anything about his legal scholarship. I don't really know of his legal scholarship, certainly at that time.
Well, I can understand it if you didn't say anything, but Dean Tuttle makes a specific statement. His words are that you said, quote, the most laudatory comments, unquote.
I have no response to that because I don't know exactly what.
New York Times on October 7th, quote, in an interview, Ms. Berry suggested that the allegations, referring to your allegations, were a result of Ms. Hill's disappointment and frustration that Mr. Thomas did not show any sexual interest in her, close quote. You were asked about Ms. Berry at the interview on October 9th, and a reporter to have said, well, I don't know Phyllis Berry, and she doesn't know me, and there are quite a few people who have come forward to say that they saw you and Miss Berry together and that you knew each other very well.
I would disagree with that. Miss Berry worked at the EEOC. She did attend some staff meetings at the EEOC. We were not close friends. We did not socialize together. And she has no basis for making a comment about my social interest with regard to Clarence Thomas or anyone else. I might add that at the time that I had had an active social life and that I was involved with other people.